Individual rights is what most of us feel is the core of constitutional law. Once you've actually studied constitutional law, you realize that the document really has a lot to do with how the government itself is organized, and that's what we were talking about on the previous videos. This video and the three that follow it will give you a pretty complete capsule summary of individual rights. Remember that a plaintiff who is seeking to establish a constitutional claim will have to show state action. And obviously, this issue is a lot more important where the defendant is a private party as opposed to being a part of government. As we consider the broad ideas of state action and individual rights, we realize that the 14th Amendment is what applies the Bill of Rights to the states. So that is a usual reasoning step as we explain how a plaintiff can bring a theory of liability alleging a constitutional violation. The various sub-issues that are involved include where a private entity, purportedly a private entity, is carrying out a public function. And that's been increasingly true over the last generation or two. A lot of government functions have been contracted out to the private sector. And to the extent that a private sector entity is engaging in what most of us would agree would be a function traditionally carried out by the state, then state action will be found. Where a private entity is taking part in what is traditionally a public function, state action has been shown. We can also see state involvement in a short laundry list of ways which are included in the outline, where we've got judicial involvement, business involvement in a traditional state action, state services and subsidies, licensing and regulation, and state encouragement of specific industries. All of these can be indicia of state involvement. But for the bar exam, the common issues that are tested are, first, the action of any political subdivision is enough to establish state action, even though obviously a subdivision is something short of a state government. Also, the action of any entity that the state has a partnership with. Again, traditionally these will be considered private parties engaging in state action. Where we've got a partnership between public and private sector, that's good enough to show state action. But remember, taxing and regulating a private business is not enough to show state action. Everybody in the private sector has to interface with the government. We all are, to some extent or another, regulated by the government. Those regulations are not enough to establish state action. So we turn to the first broadly tested area of individual rights, and that area is due process. And we know that due process breaks down to substantive due process and procedural due process. The more complicated and the more important area is substantive due process. And the reason substantive due process is more important than procedural due process is the analysis is more complicated and sophisticated. With regard to substantive due process, different standards of review apply depending on the type of regulation. So, remember, the important areas where we consider substantive due process include all regulations that involve the family and procreation. This is the body of law that's most well symbolized by Roe versus Wade, but which is much broader and much deeper than merely considering abortion rights. Remember that economic interests also, at some point, give rise to a substantive due process claim. But most economic regulations are judged by the rational basis standard. So a party has to do more than allege that they have been regulated economically. They've got to show that the regulation interferes with a fundamental right. Next, we can see that substantive due process is where laws that are void for vagueness find a constitutional limitation on the state's action. A statute that is impermissibly vague violates the Constitution because of substantive due process. Remember also that where the government seeks to retroactively deprive somebody of economic rights that have been vested, that is a taking. That gives rise to a substantive due process claim, whereas a mere regulation of economic interests does not. Remember that substantive due process is what prohibits the state from interfering with privacy interests unless the state can show a compelling state interest. That's where strict scrutiny and substantive due process brush up against one another. Now, I advise you, once again, the best way to really learn this material is to practice. See how this material is tested. You'll see, after not that much practice, that this material is tested in a ritualistic fashion. Strikingly similar fact patterns arise all over the country repeatedly on bar exams. This material is just not that complicated, unless you make it complicated by spending a lot of time studying it in a vacuum. Get into practice, and you'll see this stuff actually does make quite a bit of sense, and particularly on the multi-state, the examiners really can't play very complicated games. Don't worry, they'll play those games with you on the contracts and real property questions. So, remember that when we have a state law, which is enshrined in the state constitution, the fact that it's in the constitution of the state does not in and of itself make the statute any less vulnerable to a constitutional claim. The state constitution is just like any other state statute as far as a federal constitutional review of substantive due process. All right, that's enough for substantive due process. Get into some practice. You'll find a few little nuggets of information that you'll probably want to annotate your outline with, but trust me, up to a point. This material's not that hard. Get into practice. So, finally, we turn to procedural due process. Procedural due process is a lot more straightforward, a lot easier, and somewhat less commonly tested than is substantive due process. With regard to procedural due process, probably the most important issue is identifying when somebody has got a right to procedural due process. And broadly speaking, when somebody has lost a liberty interest, they lose a degree of freedom. When any of an individual's fundamental rights are affected by a law, and where property interests are affected, here the individual who is subject to the law typically has got procedural due process rights. Well, what are those procedural due process rights? Typically, they are the right to notice in advance of the action being taken and a right to a hearing, to contest the action in general or to contest the action as it applies to the individual plaintiff. Remember that procedural due process only is required when there is a state action by some decision maker. In the absence of state action, procedural due process is not required. And this is, by the way, this is probably the most common area where state action is actually tested. We looked at it up front as a sort of a threshold issue, but where a plaintiff is seeking procedural due process rights, the most common defense is to allege no state action. So this is where you'll probably see a little bit of action in practice. Remember that there is a property interest to employment where there is a fixed term of employment, or employment where the individual employee has got tenure or the equivalent of tenure. Those are vested property rights, and they can't be taken away without procedural due process. So, finally, remember that the core of procedural due process is notice and a hearing. Those are the things that you must remember. Now, the last area of law that I want to touch on in this first of 4 videos on individual freedoms is the idea of Fifth Amendment takings. The reason I want to touch on takings is this is an area of law that has had quite a bit of life breathed into it just during the last 20 or 30 years. Fifth Amendment takings are much more important now than they were a few decades ago. And here's where we deal with constitutional law touching the law of real property. And this is where we are dealing with issues raised by government regulation of land use. Regulation of land use by the government is the most common area where a Fifth Amendment taking claim arises. remember that in order to essentially seize land or to deprive a landowner of substantial rights, there has to be a public purpose requirement. Typically, this public purpose requirement is in the area of environmental regulation. But land use regulations, broadly speaking, can give rise to a Fifth Amendment takings claim. So, where a state engages in, or a local municipality engages in zoning or other uses of the state police power to regulate land use, that's where the Fifth Amendment taking issue can arise. But where the government can show a valid public purpose, the more strong the public purpose, the less likely the Fifth Amendment taking claim. And so obviously we can see that there is a continuum between valid regulations of land use and Fifth Amendment takings. And by the way, this is an area of law where the actual standard is something of a moving target. This is an area where the law is still evolving. So that makes it ripe for action on a performance examination, where you have to deal with varying laws on a topic and then write a persuasive or an objective piece about a specific pattern. But for MBE purposes, I think you'll find these takings issues are quite straightforward. And during our work together on hypotheticals on constitutional law, we'll take a careful look at an elaborate fact pattern dealing with Fifth Amendment takings. And my parting shot for you on this issue is to note that Fifth Amendment takings issues are very close to being constitutional law remedies cases, because here the plaintiff brings a theory of liability of a Fifth Amendment taking, and the plaintiff is seeking specific remedies. Typically, these are the same remedies that all other civil litigants are looking for: damages, restitution, and equitable relief to stop the facts that give rise to the taking. So that wraps up our first video on individual rights. Next up, we will focus our attention primarily on equal protection.